In the wake of sweeping financial reform in the summer of 2010, the Non-Admitted and Reinsurance Reform Act was signed into law and was given an effective date of July 21, 2011. In this interview with Insurance Journal's Charles Boyle, Jerry Sullivan, head of the Sullivan Group, gives his view on how the Dodd-Frank NRRA regulations will require changes in the way the surplus lines industry operates.
You've had a fairly significant change recently with the federal legislation that's been enacted and the legislation in states like California and Texas that affect the surplus lines industry. Could you tell us a little bit of your opinion of how that's going to work and how it's been implemented?
Well, this is a favorite subject of mine to the extent that being a former regulator myself, I've continued in my time in the business to do a lot of work with various regulators and at NAIC. And the issue of how do you handle multi-state risks on the surplus lines side has been an issue that's been in debate at NAIC for at least 35 or 40 years. Frankly, it never got much traction within NAIC because of issues between various states of one sort or another. But several years ago, the industry decided to take this issue to the federal camp. And as a result of all of this, and it took several years to accomplish this, there was included within the Dodd-Frank bill, which was passed a year ago today, a section called NRRA. And what this does is it changes the whole relationship as to how multi-state risks are to be handled. Bottom line is the U.S. Congress has basically said, number one, we want uniformity and we want simplicity to how these kinds of risks are handled. The NAIC, in response to this, has developed an approach called NEMA, N-I-M-A. I keep forgetting what all these acronyms stand for, but this is their approach to dealing with what NRRA has asked them to do. Some of the states, however, have decided that they would go with a somewhat different approach called Slim Pack, which is another suggested compact between states to allow them to deal with the sharing of taxes, which is the heart of what NEMA does. But within the federal legislation, there were also some regulatory issues that they suggested had to be handled, which are taken care of within the Slim Pact approach. Now, there's strengths and weaknesses to both approaches. The big issue that's in discussion today is allocation formulas. By that, what I mean is when you write a risk, the states have asked that you allocate the premium for that risk between the various states. And for example, within NEMA, they have a fairly extensive allocation formula. Now, there are quite a few people in the industry have a problem with that formula to the extent that a number of the things that the original formula that they developed, some of the things that they've asked for, frankly, even insureds don't have that information. So it makes it very difficult and very awkward. Now, having said that, there are ongoing discussions geared towards finding a simpler way to deal with this allocation issue. The Kentucky commissioner recently introduced a fairly simplified approach to allocation to the Slim Pack states. That's not been accepted as yet, although we expect that it will. And that will make it much easier for both the insureds and for their brokers and their insurers to deal with this whole issue of allocation. We would hope, but this is, I suspect, some time down the road, that we could come up with a common allocation formula to be used by all the states. That would just make it a whole lot easier for both insureds and their brokers, and I think would go a long ways towards meeting the requirements established by Congress of looking for simplicity and uniformity for this whole matter across the country.
As far as the national legislation is concerned, it seems that it's going to be taken state by state. California specifically has passed AB315 to come into compliance with the federal regulations. What's your view of that legislation?
Well, AB315, which has been in work by the Department of Insurance for actually a couple of months now, once they began to fully realize and deal with, or realize that they were going to have to deal with the many provisions of NRRA, they began to develop legislation to modify the California Insurance Code to meet what is required by NRRA. And that's what 315 is all about. There was a lot of give and take with the industry. Frankly, I think the department has done a very good job of working through a lot of difficulties, a lot of odd issues, a lot of different things. But that's the nature of dealing with this kind of both federal legislation and then trying to react to it at the state level so that the insureds in the state and their brokers can properly respond to it. 315, I think, is a very good tool. Actually, brokers and insureds who want to know more about it could go to the California Surplus Lines Association website because there's very good descriptions in there of what is required to comply with AB 315 and meet the national standards. But bottom line, what the national standards really say, and 315 supports this, is that a multi-state risk is only going to be taxed and regulated by its home state. And the definition of home state is important, and I won't try to go through all that detail here, but any brokers or insureds dealing with this can get good, clear explanations with what's available on the Surplus Lines Association's website. And that means tax goes to the one state, regulation is done by the home state, and then it's up to the states, as they desire or not, to share tax with the other states where that particular account may have risk exposure.
Okay, you're talking about the insured's risk exposure. What would you say, how are the new regulations going to affect a company like Sullivan Group? How do you work with the insureds to make those changes, or how do you plan to?
First of all, we're doing a lot of work right now making sure our own people understand 315 and understand what they have to do to comply. Now, we operate in a lot of different states. And at the moment, different states have different requirements. We're hoping to smooth that out over the next months and year or so. As a matter of fact, the Council of Insurance Agents and Brokers has just published a NRRA guideline. It runs 134 pages, so it is not an uncomplex issue. But we have gone through this now pretty thoroughly and training our own brokers as to what they have to do. And then in turn, we have to make sure our insureds know what they need to do to comply and the kinds of information that are needed. That's why what I was describing a few minutes ago about this work between the Slim Pack states and we would hope the NEMA states will come to a common approach to allocation, which will make it simpler for everybody.